The defense of voluntary intoxication. Voluntary intoxication is very straightforward. That is when the defendant actually ingested a substance intentionally, knowing of its effects, and it was not under duress. So, what does that mean, and what exactly does his defense actually do? So, example, let's just pretend that Riley sniffs a line of cocaine. He intentionally sniffed that line of cocaine, right? That is an example of Riley intentionally taking in that substance and being voluntarily intoxicated by the cocaine. So he was not under duress when doing so. We'll talk about that in a second. But he was not under duress when doing so. He did it intentionally and voluntarily. Therefore, that is why, even though he's intoxicated, he did it voluntarily. Therefore, that'll be a defense for specific intent crimes only. Not general intent crimes and not malice crimes and not strict liability crimes. Remember, that is very big. It is not a defense for general intent crimes like rape. It is not a defense for strict liability crimes like statutory rape. It is not a defense for malice crimes like arson. That is very important to remember. But it is a defense for fiat. F-I-A-T. First degree murder. Inchoate crimes, solicitation, attempt, and conspiracy. A, for assault with the intent to commit a battery or attempted battery. And lastly, for theft crimes like larceny and embezzlement and false pretenses. So remember that. Voluntary intoxication will be defense for those crimes, but not general intent crimes like rape, not strict liability crimes, and again, not for malice crimes like arson.